Okay, I'm going to move into estate planning, and I should say for those in the room, you may have some questions, please note them. I have a list of other questions, but I will definitely open it up to questions at the end. I just want to make sure we get at least the base information out there for everybody, okay? All right, I know I'm moving quick, bear with me. All right, so now we're going to talk about estate planning. Some of this I will skip some slides and move around. The idea here with the estate planning section is to give you some information on what it is, why you should care, and how it could also be helpful even with the changes that we may be seeing under the current administration, I'm going to call it. Okay? All right, common myths. So I'm just going to pop all those up. It looks like I had them one at one. All right, these are some common myths I hear. Basically, common things you hear: I'm single, I don't need it, or I'm married and I don't need it, which is always ironic to me that in both situations people think they don't need it. We don't have enough assets to require estate planning. You're going to find out in just a moment, estate planning is not just about your assets. In fact, estate planning to me is about so much more than your assets. Your assets are like one piece of the puzzle, but what happens during your lifetime, right? And what happens to those you love, whether in relation to the assets or something else. So we're going to talk about that. And then we own everything in joint tenancy, or we have beneficiary designation, so it's all going to my spouse. Yeah, okay, maybe that will work on the first level, but what about the second level? And what about if there's some issue? Maybe the life insurance company didn't actually put the beneficiary on the account that they were supposed to do. So we're going to, again, go through, as we move along, why that's not the case. So what is estate planning? I use the phrase estate planning as sort of an umbrella term for a bundle of documents, right? And these are documents that prepare for the care of you, your children if you have them, and or your spouse or partner, partners, or loved ones of whatever form, as well as preparing for the orderly management of your affairs and then everything you own. So yes, the assets are lumped in there, but also it's during incapacity as well as the end of life process, so while we're maybe actively dying, and or after your death. And the documents as a whole, the idea is they stand as a unified statement of your intent. At the end of the day, it's about control. That's what it's about. It's about me controlling how those things process rather than letting the terms that the state of Colorado has written in their statutes control, or letting people I wouldn't pick control because they're in the statute, right? So it is about control. Not about, oh, I got to control this after I'm dead because I just want to control my daughter from the grave. Not that kind of control. Maybe for some people, but that's not what we're focused on. We're focused on controlling it so that it happens the way I want. All right. So why do you need them? For you, medical and housing decisions, where are you going to live, who's going to make medical decisions for you, even some decisions in end of life, such as what type of medication or medical treatment am I getting and for how long, financial decisions for you, who's going to make those, your last remains and your service, how's that all going to process. Keep in mind, for instance, if I haven't done my planning and controlled these things, that the state of Colorado has some answers, and that's either going to be who gets to decide, or it's going to be what the decisions are. And it could be, if I am not married but in a long-term relationship, it could be a parent that I have no relationship with suddenly comes in and has authority over these things, right? And maybe they don't recognize me. Maybe the person that's coming in would put me in a dress and in a casket. Both of those things, never going to happen if I have control. You won't see me in a dress unless it's some unique party and there's some reason I'm dressing out of character. It's just not who I am.
You'd probably more likely come as a casket.
that is probably true. I come as a corpse. And I won't be in a casket, just so you know. I also won't be having a Catholic service, though I was raised Catholic. So those are things that for me are adamant, right? And there are totally people in my life that would come in and do some of those things. maybe out of purported love, maybe out of their desire for what they want, but this gives me the control, right? Where do I live if I'm incapacitated? Is it going to be Colorado, or are they going to ship me back to Oklahoma or Kansas? Neither one of which do I ever want to live in again. So those are the types of things that we're talking about for you. What happens to your assets upon death, right? That's the other piece. Why do you need estate planning for your spouse, partner, partners, or even just loved ones that are just, you know, best friends or whatever the case may be, your adopted family, your tribe. So they have the authority to make decisions. Also, what about the house? Do you all live together, but the house is in your name? I have had more instances of people being kicked out of home because there was no planning and the person passed. It is so common that comes up, the family swoops in, and suddenly someone's out the door. So what about the house or the living scenarios? Can they support themselves financially without your income? If you have lived as a unit, no matter what your relationship, even if you are just the best of friends, if you have lived as a unit, you have had some financial dependency or interdependency that is built up over time. You now pass away and they don't have that financial contribution. It could be life altering. It could be the kind of thing that sends them into, you know, homelessness. But maybe the assets were there and you intended for them to help them, but the planning wasn't done. And now your long lost relative, uncle, aunt, brother, whatever, has inherited that. Can they be excluded from things? Again, that's not only the home. I've had people excluded from services, funerals, the hospital, not right, the last moments of life, mortuaries, you name it, people can be excluded. Who receives your assets? Again, that's always on the list. For your children or child, if you have them, is there someone with, if they're minors, someone with legal authority to make decisions for the child in your absence, who will take care of them, again, if they're minors, and that's whether you're disabled or deceased, right? If I'm suddenly completely incapacitated and I have a minor child, and there's no other legal parent, so maybe my spouse died in the accident and I'm incapacitated, and our child is a minor, somebody needs to take care of them while I'm recovering, whatever that looks like. If I haven't nominated the person, then the court will have to make that decision, and that can be a total knockdown battle, and it may mean that your kid is packed up and moved out of state, right? It's possible. Will they inherit your assets, and if so, will they be managed? Again, for your children, it's the question of where the stuff goes, but also, depending on how old they are, or who they are, is there some protection built around that inheritance, or is it just a check going to them straight away? My daughter is 24, and she knows I have these conversations all the time, using her as an example, and the idea of her inheriting $20,000 suddenly today is scary to me and my spouse. I often say that I know that during the Taylor Swift tour, she would have been at every show. And there would have gone that inheritance, right? So she knows she's a Swiftie, and that's where it would have went. And she would have claimed it was managing her grief. So do we control it? Do we put it in some sort of a special trust for them and have a little control? Maybe not over control, but control. Is your spouse or partner the legal parent of your children? Again, this goes back to, if they're not, do you have documents in place? Because maybe that is their psychological parent, right? That's the only parent they've ever known. And do they have the ability to continue with them as the guardian and conservator? You got to do the paperwork for that to happen, because otherwise they're fighting family who has priority over a legal stranger. All right. This is a list of the core planning documents. Okay, so core set of estate planning with my office. I don't know if you can tell there's some color on the optionals, but there's 2 optionals. But the core set is 6 documents. Memorial instructions, that's saying what happens to my remains, or at a minimum, who can control them. What about services, or at a minimum, who can make those decisions. Financial power of attorney, that's someone during my lifetime that can manage that businessy side of you. It's not just about your checking account. It's about moving money from the IRA to the checking account, but it's also about signing your tax return, selling your house, paying your rent, making sure your insurance is up to date, renewing the tag on the car. All of that's business sort of stuff that we do day to day, and some of it we don't think about. That's what your financial agent's doing. Medical power of attorney, that's someone to make medical decisions for you and also decisions about sort of your day-to-day care. So who's your doctor? Are you living at home? Are you in a rehab facility? Are you in assisted living? Do you have in-home care? Whatever those needs are you being fed? Just making sure that you're being cared for at sort of that personal level with your medical decision making as well. Those two powers of attorney are only effective during your lifetime. Those powers both die with you. Living will, this is end of life decision making around medical treatment. Do I have life-sustaining measures? This is the old, are they going to pull the plug kind of question, right? That's what the example every client gives to me, and that's essentially what it is, right? So it's life-sustaining measures for how long, do they get them withdrawn? HIPAA authorization is a release of healthcare information related to, in our office, it's focused on capacity, and it's for your financial agent. We want to make sure they're not going to hit that healthcare law that says they can't get access to protected information. So we give them a release, right? It's very limited. And then the will, that's going to control your assets, right? That's who's managing your estate and where do the things go after your death. If you have minor children, we're going to do a nomination of guardian. That says who can take care of those kids if you're incapacitated or if you've passed away and the other legal parent isn't available, which could include that they're just a bad parent. That could be unavailability, right? We have that come up in cases of divorce and different things. And then also optional is a trust for yourself. That's what we call a revocable trust. That's a longer discussion than we'll definitely have tonight. Your will can have, if you have a minor or if you have a young adult, it can have those trust provisions like I talked about for my 24-year-old, right? That would be built into my will. All right, so that's the core set of planning documents. If we don't have the powers of attorney, then what's going to happen is if they can't agree, everybody that's piled into that doctor's office, if they can't agree on what to do with me medically, somebody's got to go to court and be appointed as my guardian. There is a list of priority as to who gets first dibs on that. If I'm not married, then it's going to start working through, adult child, parents, siblings, all those sorts of folks. Financial power of attorney, if I don't have one, they're going to have to go to court and get appointed as a conservator. So they won't have access to my finances or my house right away. And the HIPAA document that we talked about that I've already explained. Living will, which I talked about earlier, if I don't have that, then depending on if I've done a medical power of attorney, they might have some authority to make decisions. Otherwise, it may be that I'm connected until there's some agreement or a guardian appointed that can have authority over that. Nomination of guardian, if I have not nominated them, there is a list of priority in the statute. It starts with the legal parent, if there's not one, or if there's a question as to their legality, then it's going to start looking at grandparents and so forth down the list. Memorial instructions, if I don't have those, everybody sitting at the mortuary is going to have a voice. And for the most part in Colorado, if they don't agree, there's going to be a default most likely to burial rather than cremation. And then part of the theory, as I've often read, is that it's not as permanent, which I'll debate that. But either way, it's going to be burial. As far as services, if they don't all agree, then it's kind of who pays. And sometimes it can be we have multiple services. It can be people excluded and some people never have a service. It can be a mess. And as I mentioned earlier, they don't have to respect my wishes. Assets. Two types of assets. This is the main thing I want you to know about your assets as we kind of wrap up here and get into questions. There's two types of assets when we die. Non-probate and probate. And this is important because even if you have a will, you can use non-probate tools to help strengthen your wishes so that there's less chance of a challenge, right? So the probate, everything in the probate column, that's going to be controlled by your will. Or if you don't have a will, then the laws that the will that Colorado has in the statutes, we call it laws of intestacy. Otherwise, non-probate assets are things, anything you've set up a beneficiary designation where the beneficiary survives you. So that's life insurance, IRAs, investment accounts, sometimes bank accounts. If you put a beneficiary designation, pay on death designation, transfer on death, those designations control. So if I say on my life insurance that the beneficiary is Kyle, and in my will I say everything goes to my wife at my death, my wife is going to think that includes the life insurance, but Kyle is going to go, nope, that is my life insurance policy.
That's me.
I know, and Kyle will be quite pleased with that. So those control. So look at them and use them, right? If you haven't updated them in years and you realize you've still got somebody on there like a parent and you're in a relationship, you better evaluate if that's the right call, because that's who gets it. They're going to take that tax-free, most likely, and run. Joint tenancy. If you own real estate in joint tenancy, what that means is if the other owner survives you, they now own the property in its entirety. So joint tenancy is a great tool for passing our real estate. Though there are occasions that you don't want to use it if we're not married or if we have some reason, if it was all my investment, something like that. So you have to evaluate it, but it is a great way to pass our property to our spouse without requiring probate, which is what you do with a will. Jointly owned, bank accounts that are jointly owned, investment accounts that are jointly owned, vehicles, anything like that. If you jointly own it and they survive you, it's going straight to them. And then anything you put in your own revocable trust, which is more than we're not gonna get deep into that today. But those are all non-probate assets. There are a few others. Personal property, if we're married, personal property that is jointly accessible is presumed to be a non-probate asset. It's presumed to be a joint, and so that would fall in this column. Everything else is probate. What happens is if you've really done your planning and you are married or in a civil union and you've done a good job with your planning, a lot of times my clients, when the first one passes away, they will not need probate for the first person to die because everything will fall here and the spouse gets it automatically and we just don't have to mess with it, okay? And those are tools you just use also to support your control, to back up what your wishes are. And this is essentially what happens under the state of Colorado. So if I don't have a will, the state of Colorado has one for me. It's called the Laws of Intestacy. We're not going to get into the details and the numbers, but basically the one thing to understand is that if I'm married and I don't have children, so I'm married, neither one of us have kids, there is a portion of my estate that will go to my parents if I have not done a will. Part of it goes to the spouse, and part of it's going to the parents. Even if I haven't talked to them in 20 years, doesn't matter, part of it's going there. Another thing to remember is that if the children, if one of us we're married, but one of us has a child that is not the child of the other, there is some dividing that happens. And so that's the other thing. And that may not be the intent, right? So this is something to consider. Just understand you've lost control. Colorado has a will for you. Most people don't like it. If I'm legally single, then if I have children, everything's going to, again, if I don't have a will, everything goes to my kids. If I don't have any kids, it's going to the parents. If there are no parents, then it's siblings, and then it works through the family tree from there. So again, may not be what you intend. It could be, might be. All right, the other thing is, if you have will planning, you're going to be able to appoint who you want to manage your estate. They're going to be coming in your home. They're going to be going through all your drawers. They're going to go through pictures. They're going to go through all the little hidey holes in your bedroom, your closet, wherever they might be. So think about who you want to manage your estate, right? I don't care if you're LGBTQIA or straight. I'm sure there's some things in your home you might not want everybody to see just because they don't know you on that level. They're going to see it if they're managing your estate. Decide how your assets will be distributed. That's part of why you're doing planning. Trust planning, I'm going to skip through this because not everybody needs it. There are reasons that it can be helpful for our community. We used to use it before marriage was an option, a lot more, still use it a lot. It is a longer conversation than tonight. So if you want to talk about trust planning, call my office, get an initial consult. I don't charge for that. I am happy to talk to you about trust planning.